In the last video, I described the nature of a patent. I mentioned that the state would enter into an agreement with you to protect your invention, provided it was satisfied that the invention met certain requirements. One of these requirements is the novelty requirement. This requirement is the reason why your patent attorney will query you about the status of your invention before taking on your case. So what do we mean by novelty? Well, for starters, it's an international requirement. That means that any public information anywhere in the world on the date of filing your patent application will qualify as material that can be used to show that your invention is not worthy of a patent. This is a strict requirement, but there are a number of countries that have a grace period that allows applicants to get valid patent protection even though they've made the invention available to the public. Australia and the United States, for example, have a grace period of 12 months. Now, using the grace period should be avoided. For example, you would not be able to enforce a patent against a third party who decided to take steps to exploit the invention during the grace period. There are also other issues around the grace period that are, they're just maybe just a little bit too complicated and probably way too boring for this video. Now, in order to assess the novelty of your invention, the patent examiner will carry out a search. This search is primarily a patent search and is carried out through roughly 90 million patent documents at last count. There's really no excuse, though, for not having a good idea of what may be out there to cause you problems. That's because you also have free access to those 90 million patent documents. So before even phoning your patent attorney, you can do some research. You can start with a simple Google search to just see what's been commercialized and get some idea of terminology. And then you can follow that up with a search through a free patent search portal like Google Patents, for example, which is actually pretty good. But before you do that, I recommend that you get a piece of paper and just write down your invention in a fairly short paragraph using broad terminology. Then you can use the terminology in your paragraph to work out your search queries. And then you can also have a look at those words, and you can look up similes for those words as well. And you need to consider whether the words have the same meanings in different jurisdictions. The United States, for example, is notorious for using different words to those in Australia for describing the same thing. If you get confused or you lack confidence, then it might not be a bad idea to contact your patent attorney to investigate having a professional search carried out. So I'm going to wrap this video up here. Don't forget the golden rule. Keep your invention strictly confidential until such time as you have seen or spoken to your patent attorney. Thank you very much for taking the time to watch this video.